Now, I am going to dictate a legal passage at the rate of 120 words per minute. 5, 4, 3, 2, 1, start. Let's start. I have heard learned counsels for the petitioner as well as respondents and have gone through the evidence lead on behalf of the parties, including the MACT case number 406/2021 within bracket FIR number 210/2021 Bipin versus Vijender Singh, and whether the petitioner Sri Bipin, son of Sri Naresh, suffered injuries in road traffic accident on 0.07/2021 at 8 p.m. at Bhagavan Mahavir Mark towards the helipad Pal Colony, Kat Rithala Village, Delhi, due to rash and negligent driving of offending vehicle bearing registration number DL-1PC-4458, which was being driven by driver Sri Vijender Singh, son of Sri Hawa Singh, on the said date, time and place manner. It is well settled that the procedure followed for proceedings conducted by an accident tribunal is similar to that followed by a civil court, and in civil matters the facts are required to be established by preponderance of probabilities only and not by strict rules of evidence or beyond reasonable doubts as are required in a criminal prosecution. The burden of proof in a civil case is never as heavy as that is required in a criminal case, but in a claim petition under the Motor Vehicles Act, this burden is in fact even lesser than that in a civil case. Reference in this regard can be made to the propositions of law laid down by the Honorable Supreme Court in the case of Bibala Devi and others versus Himachal Road Transport Corporation and others, reported in within 2009 13 AC 530, which were reiterated in the subsequent judgment in the case of Parmeshwari versus Amir Chand and others 2011 within 1 ACR 1096 within civil appeal number 1082 of 2011, and also recently in another case, Mangla Ram versus Oriental Insurance Company Limited and others, 2018 lawsuit within bracket SC 303. As already discussed above, the petitioner examined himself as PW1 in order to prove the facts regarding the occurrence of the accident. PW1 has clearly and categorically stated that at the relevant date, time and place, the offending vehicle being driven at a high speed and in a rash and negligent manner by R1 hit his motorcycle, due to which he fell down due to the impact and he sustained grievous injuries. PW1 was cross-examined at length on behalf of insurance company. PW1 has disclaimed the suggestions of respondents suggesting the occurrence of accident due to his rash and negligent driving. None of the respondents could bring any material on record which was inconsistent with the version of the petitioner. There is nothing on record which suggests that oral testimony of PW1 would not be believed. As such, this tribunal finds it appropriate to hold that the oral testimony of PW1 is reliable and trustworthy. The very fact that R1 has already been charge sheeted for the offences punishable under sections 279/338 IPC in the above criminal case FIR in itself is a strong circumstance to support the above oral testimony of PW1 and the case of petitioner on this issue. The copies of FIR charge sheet and MLC also corroborate the oral testimony of PW1. Stop. Thank you. Jai Hind. Jai Mera Bharat.